Good morning, Your Honor. Jessica Warden for the petitioner, Sarah Davis, who's present as well. This is a default on grandparent access, so I expect about 20 minutes or less.
And this is Rosaura Rodriguez, the co-managing conservator, pro se.
Okay, so it's not a default.
Oh, I guess not. She never answered the suit, but here we are. Great.
Okay, are you ready to proceed, Ms. Rodriguez, and how long do you think the hearing will take?
I'm ready. I did submit, I sent a response letter, so I'm not sure if you guys, if you're able to see it, but I don't know. I don't know how long it'll take.
Would it help for you two to chat while I call through the rest of the docket? Do you want to go in a breakout?
I think a breakout room might be helpful for us. This is the first time we would be speaking, and if we have to go forward with her here, would be the hour we announced for then.
Actually, you can ask for 45 minutes.
Oh, well, we'll stick to that if
We'll
she's
see
going
what I got some time back.
And I don't think it'll take long, and it shouldn't. And if it does, then it shouldn't take long.
Okay, great. I'm going to
Okay.
ask Ms. Chambers to send you all an invitation for a breakout room. Y'all go ahead and see what you can come up with, okay? And
Thank you.
I prefer not to do that.
Oh, okay, never mind. All right, that's fine. Next up, we have.
Yes, Your Honor. May I give you just a slide opening?
Please, because yeah.
Okay. Well, I'm representing Delbert and Sarah Cunningham, and they're the maternal grandparents of Haley's mother is Ashley and was served with citation in April 17th, 2024, and has not filed an answer. The father is unknown. Mr. Daniel Nelson with the Attorney General's office, I sent a copy of the pleadings to him and told him about the setting today, but he said that the Attorney General has no interest in the case. They would not be appearing today. We are asking that the Cunninghams be appointed as non-parent sole managing conservators of Haley. We're asking that Ashley Cunningham be appointed as possessory conservator and to have supervised possession of Haley on the first and third Saturdays of each month from noon until 2 p.m. when she gives 7 days written notice with the Cunningham supervising at a place of their choosing. We're also asking that Ashley has weekly video conferences with Haley. We're asking that Ashley take the 12A panel hair follicle drug test at her own expense at a certified lab, such as Pro Results, with a release given to the lab so that they can send the test results to the Cunninghams. After Ashley shows that she's been clean of drugs for a period of a year, we're asking that she take the 12A panel drug test at the request of petitioners at intervals they choose. And if she tests negative, then we're asking that the petitioners reimburse her for the test at that time. We're also asking that Ashley not take illegal substances or drink alcohols for 12 hours prior to the time she has her supervised possession periods with Haley. We're also asking that if she attends school activities and field trips and those things, that you order that it's okay for her to attend once she's been drug-free for a year.
I'm going to back up a second and ask you, first of all, I need you to are you going to put up on some evidence as to why the grandparents have standing? And I need to know where this child is and how.
Okay, well, Haley had been living with them, Your Honor. Actually, they picked her up when she was a month old because Ashley was in a treatment facility. It was kind of a halfway house. She had been in jail, but she had Haley when she got out of jail, and she was in this rehab facility, and I believe that they'll be able to testify more about it, but she didn't want to she went back to jail for a period of time.
Okay. I see that now. I saw it in your pleading. I missed it, but okay.
Okay. And they're not asking for child support, nor for Ashley to pay for health insurance. Miss Cunningham has had her on her health insurance with Blue Cross for quite a long time. And
how old is the child again? She's almost 3. She's 2.
Yes.
Okay. And they've had her since she was just a baby?
Yes, with some of that time, her mama did live there, but not not consistently.
Okay. All right.
May
Yes.
and I'd like to swear in both Mr. Cunningham and Miss Cunningham. Sarah Cunningham is the stepmother of Ashley. I'd like to direct the questions to her, but maybe have Mr. Cunningham chime in on just one or two things. But he's the
Sure.
biological, he's the biological father of Ashley.
All right. If you both unmute yourselves and raise your right hand so Ms. Palmer, you may proceed.
Thank you, Judge. Miss Cunningham, would you please state your name?
My name is Sarah Cunningham.
And how are you related to Haley?
I am her grandmother, aka Grammy.
And how old is Haley?
She will be 3 in October, so she's a little over 2.5.
And where do you live?
We live in Maynard, Texas.
How long?
It's been around 30 years.
Okay. And who lives there with you?
It's my husband, myself, Haley, my husband's mother, and our youngest daughter and her boyfriend of 2 years.
Okay. And how long has Haley been with you?
Since she was a month old, on her month-old birthday
And
of 2021. Sorry.
how is she doing?
She's doing great. She is a energetic little kid that loves to learn and socialize and just she loves family. She goes with the flow most of the time.
Okay. And please describe what caused Haley to come live with you and Mr. Cunningham.
So at the time, Ashley had been staying at it was a Christian ministry home, halfway house, in between her jail sentence and moving to the prison environment. And we got the call that she was ready to leave and she couldn't take Haley with her. So we were asked by CPS to come get her that day.
Did Ashley live with you after she got out of jail for a while?
Yes, so she was released from prison on June 26th, I believe, and she stayed with us for 2.5 months.
The June 26th of what year?
Of 2023.
Thank you.
You're welcome.
And what during that time would you tell me a little bit about her activities and the people that she was around?
So she was able to get a job briefly at Pizza Hut. And she spent some time making some bad choices. She would ask to be taken to the park that is close by in our neighborhood and to walk and clear her head. And we found out later that she was actually meeting up with a guy in the woods and doing sexual favors for the guy. She also met several other people on this app that she was part of. But while she was home, we supervised and encouraged her to take care of Haley the best she could. But a lot of times she would put Haley in her crib and then go outside. And at least a couple times she forgot to feed Haley. So we had to be the backup for times like that.
Well, after she left, after the 2.5 months that she spent there, where did she go?
She went to numerous places. She on September, let me look at my notes, September 16th, just a person that she had met on one of her apps agreed to come pick her up in downtown Manor and took her back to clean. She had been without drugs for nearly 2 years, and that day that she left here, she started right back up in drugs. She moved from Colleen, never staying anywhere for any long length of time. She went from Colleen to Elgin to visit briefly with us, and then she went to another town and stayed there for a week. It was close to Navasota. I don't even know where that is. And then she went to Austin and she was supposed to come visit a few times and never showed up. And then she went back to Brady. She always goes back to Brady because that's where her maternal family is.
Do you have concerns about Haley being with her there in Brady?
I don't believe she has the ability to pay attention to a child and provide everything that's needed to raise a kid. And she would be around ex-felons and just really bad suspects that could possibly be very hazardous to Haley and Haley's health.
Has Ashley talked about getting into rehab?
So rehab, when she's having a good day, she talks about getting into rehab, or when she's having a really bad day, she talks about getting into rehab. In the past several months, we believe she's tried to get into, I think we counted 5 or 6 different rehabs, and either something would come up or she just wouldn't show up, or, she would drop it because she felt better that day. We believe she's currently in a rehab in Killeen after having tried to go to a rehab in Page, which is closer to us, but that lasted like one night before she went to the one in Killeen.
Okay. And you asking for drug test during the first year to, I mean, for her to show that she's drug free for a year.
I just think it's better for her to be around Haley and that, without any drugs in her system.
And why are you asking for the supervised possession?
For the safety of Haley and to be able to give Haley the life she deserves because she matters.
And would you just briefly describe the mental health issues that Ashley has dealt with?
So starting in elementary school, she would be disruptive in class. So they had to start putting her in behavior management classes. So she was in behavior management classes and not in the mainstream classes all through elementary and middle school. It included her actually having to have one-on-one because she would get extremely physical and they had to be certified to handle that. We took her to many doctors to try to figure out what was going on, and they diagnosed her as ADHD. She was on medication. It helped sometimes it didn't. I'm not even sure if she really took the medication as she should have, because sometimes, she had to take it at school. As she got older, things got more physical here at home. She became kind of dangerous to her siblings. Her father worked at night as a security guard. So a lot of times it was just us alone at home, and there was some fear there. And eventually, as time went by, my husband actually saw how aggressive she could get, and cops would be called, Travis County cops, deputies. And there were a few times where she had to go to Shoal Creek. It kind of became a habit for her. She kind of enjoyed, being able to socialize with the people at Shoal Creek. So she knew that, she could get in trouble this way, and, we would call the cops and she would go to Shoal Creek. Eventually, she made threats to her younger sister, Morgan, and mentioned that while she was at Shoal Creek. And so we requested that her biological mom actually pick her up. And that is when she started living in Brady, Texas at the age of 15, I believe, maybe 16. And she picked up on all the habits of that side of her family in Brady.
Is there anything else you think that it's important for Judge Mauzy to hear?
Since we picked up Haley when she was a month old, we've really encouraged her learning, and she finds it fun, and she feels safe, and we just want the best for her. And we still want Ashley to be a part of her life because she deserves that. But we want the good side of Ashley and not the under drugs and possible health issues, mental health issues that she does come with. So we just don't think it's a full-time type thing to be with Ashley at this time.
That's all I have for Ms. Cunningham, Judge.
Thank you, Ms. Cunningham.
Thank you.
Ms. Palmer.
If I could just ask Mr. Cunningham a couple of questions, please.
Go ahead.
Mr. Cunningham, you've heard the questions and the answers. And do you agree with those answers?
100%.
I'm sorry, what, sir?
Absolutely agree.
Okay. Is there anything else you would like to add to tell the judge, anything that you think we've left out that might be important? Or have we just about covered it?
Pretty much. I just kind of feel, and she does too, that Ashley has an issue of keeping the wrong company. She really doesn't follow anything through. When we get, of course, emotionally invested in Ashley, and Ashley going to rehab and saying she's trying to turn her life around, she breaks our heart every time. And we really do want what's best for Ashley, but at this point, we're worried about Haley and her safety.
That's all I have, Your Honor.
I have a question, and I guess either Mr. Cunningham or Ms. Cunningham, have either of y'all heard from Ashley since she was served with your petition back in April?
We've heard from her. She text messages us, she calls us, and we do encourage, video chat every once in a while with Haley.
Did she mention being served, or did she say anything about the fact that y'all are seeking these orders?
She really avoids the topic altogether.
Okay. Okay. And then just one other question. I see on your, Mr. Cunningham, you signed the military service affidavit. How is it you know that Ashley's not in the military?
I'm sorry?
How is it you can file this affidavit and state that you know she's not in the military? Because it doesn't really say. So I might need you to, how do you know she's not in the military?
Well, through communication with her.
Okay, when's the last time there was any communication with her?
A few days ago.
Okay, and that's when you found out she was in rehab in Killeen?
Yes, ma'am.
Okay. Okay, thank you. Those are all the questions I have. Anything further, Ms. Palmer?
No, Your Honor.
Let me say to Mr. and Ms. Cunningham, Haley's a very lucky girl, but she has grandparents that were willing to step up and take care of her. And thank you for doing that, especially taking in a month-old baby. I bet that wasn't in your life plan at that point in your life. But again, she's lucky to have you. I've reviewed the file. I see that there's a certificate of last known address on file, an affidavit of military service. And for the record, let me state that there is on file a return of service showing that Ashley was served in Brady, Texas on April 17th, 2024. Oh, I do have one other question. Why is the certificate of last known address give a PO box for her rather than an address?
So we provided the last known address of her family because she is never in one place for very long, and they have had that PO box since I've known them. So that is her maternal grandma,
Okay.
and I just think that's the best way to get something to her.
Got it. I understand. All right. Well, with that, I will grant the relief that has been requested. Ms. Palmer, have you prepared an order?
Yes, Your Honor, and I sent it to Ms. Chambers has a copy of it. I sent it twice because the first time I sent it, when I opened it up later, it looked kind of off-centered. So I sent the second one to
Okay. Did you send a BVS form as well?
I have not. I need to do that. I'll get that done shortly.
If you could resend that, please, this morning. I'm not going to sign the order until I get the BVS form.
I will. And Ms. Cunningham, I'll give you a call when we finish this so you can help me with that information I need to put on that form.
Yes, ma'am.
Thank you.
All right. Thank you very much. I wish y'all the best of luck. I hope for Haley's sake that Ashley gets the help she needs. But thank you for stepping up.
Thank you, Your Honor.
For Haley. Y'all may be excused.
Thank
Thank
you.
you.
You got it,
Thank
Your
you.
Honor.
All right. Let's, for the record, let me have appearances, please.
Jessica, I'm sorry.
Sorry, go ahead.
Jessica Warden, attorney for the petitioner, Sarah Davis.
Rosaura Rodriguez.
Thank you, Ms. Rodriguez. Okay, so let's start with Ms. Warden. So we don't have a default because Ms. Rodriguez appearing here and is an appearance.
Yes.
Correct.
The written pleading. You want to explain to me what's going on and what relief you're seeking?
Well, we have a child named Clementine, and she will be 3 in October. There is a SAPSER from March of 2023, where Miss Rosario Rodriguez is named the managing conservator, and the biological father is named a possessory conservator. Both parents of the child are currently incarcerated and have been for quite some time. Prior to filing, my client, Miss Davis, the paternal grandmother, had visitation with her granddaughter. She was in contact with her granddaughter. And then when her son became incarcerated, she was unable to visit her granddaughter. So we have been trying for almost a year to try to get some type of visitation or reach Miss Rodriguez. And it's been quite difficult, to say the least. So we're here today. We believe the evidence will show that Miss Davis has standing, that she had contact with her granddaughter, that it would be in the best interest of her granddaughter for her to continue contact, particularly with 2 incarcerated parents.
So I gathered that Miss Rodriguez is the paternal grandmother who was.
Miss Rodriguez is maternal grandmother.
Oh, okay. Yeah,
Yes.
that's where I said that wrong. All right. Thank you.
No problem. And today we are asking for grandparent access for Miss Davis on the first Saturday of each month from 9 to 5. And we're asking for electronic communication between Miss Davis and her grandchild once a week on Wednesdays. We're willing to work with the hours that work for the kiddo and school and bedtime. We have a 3-year-old, so we're willing to work with that, but we do want to make sure she has consistent communication between visits. And that's it, Your Honor.
Thank you. All right, Miss Rodriguez, can you tell me your position and what relief you think I
My
should?
position is, I believe it's a waste of the court's time since she has no standing. She has in the past, when the baby was born, seen the baby. That is correct. But she hasn't seen the baby for almost 2 years and a half or 2 years. Calvin does have, which is the father, has supervised visits. And for a year and a half, he's used 2 of them before he got incarcerated. And that's where she's referring to, where she's able to see the grandchild. From my personal knowledge, based on Mrs. Davis's mother, Mrs. Davis, in my opinion, is not a relationship that I would like for her to be around my grandbaby, because she doesn't get along with her mother or her child, Calvin. And I don't know,
Is Calvin currently incarcerated?
based on the knowledge, based on what they're saying, yes, I think so. Now he is, but he wasn't prior. And it's just based on knowing Calvin before he would be abusive to my daughter. He would talk about his mother. He would, say, I don't have a good relationship with my mother. And then also I went to Mrs. Davis' mother's house and I spoke to her in person. She also explained the same thing. She said, I took care of Calvin because my daughter does not get along with Calvin. And also she gets upset with me many times. She gets angry with me. She stops communication with me. And it's just, I don't know Mrs. Davis personally. I've never got a chance to meet her or anything. I just know based on Calvin and her mother. So based on that, and based on her not having seen Clementine for almost 2 years and a half, I prefer to keep it the way it is. Maybe later we could, get to know each other so I could see something different than based on what I know. But right now, I don't think something forceful, which is like a forceful visitation, is going to work for me.
Okay. Okay. I can hear evidence, Ms. Warden, got 45 minutes or an hour.
I would
And
keep it.
let me ask Ms. Rodriguez, I'm glad you're here, but is there a reason you didn't file? You were obviously served with citation.
So the reason it took a while to serve me is because I don't live in that home where I was served. I moved homes because Calvin would get, he would get under the influence of so many different pills and stuff that he would take, that he threatened my 16-year-old, my 9-year-old, and my 5-year-old, because I have 3 little ones, and myself, my husband, and my ex-husband. So I prefer nobody to know where I live, because home is supposed to be peaceful. And so, yeah, for my safety, it's just better for me to be like that. I finally got that letter because I know the people that stay there, and it was stuck on the door. And so they gave it to me. And that's how I knew about it.
When were you made aware of it? So I'm trying to look at it.
About,
Here,
it's
but-
been like a month, like 30 days, I think. That's when I also submitted a response. I did it myself, obviously, because I've already, when I did get her sole managing conservator, I wasted thousands and thousands of dollars. I also pay for childcare. I do everything. I don't receive anything from the mom or the dad, obviously my daughter or him. So it's all on me if it's been on me for 2.5 years. So
Okay,
I
so
don't
I'm
want to waste more money that I could use on her or my little ones instead of courts and
Right.
attorneys and all of this stuff.
So you don't live at 1504 Estrellas Drive.
I do not.
Right? You're here, you're making an appearance.
Yes.
Then given all that and that you weren't, didn't sound like there was proper service. I mean, there was well, whatever. I'm glad you got it. Are you ready to proceed or with a contested hearing today?
I am ready to, yes, I am.
Okay.
I mean,
All right, Miss Warden, you may proceed.
Okay, I'm going to start with Ms. Rodriguez briefly. Ms. Rodriguez, can you please state your full name?
Miss Warden, if you want to call her, I have to swear in the witnesses. Miss Rodriguez, please raise your right
And who
hand.
is your daughter?
Jennifer Gonzalez,
And she is the biological mother of Clementine.
correct,
And is your daughter currently incarcerated?
correct.
How long has she been incarcerated?
Going to 2.5 years.
And do you know how long she will remain incarcerated?
Not currently,
When's the last contact you had with her?
yesterday.
And you mentioned you've never met Miss Sarah Davis before, is that correct?
No, not in person. I've never had a chance to speak to her. Nothing. No.
And you don't have her phone number, do you?
No.
Now, there was an order from 2023, March 2023, and you were named the managing conservator of Clementine. Is that right?
So managing conservator, correct.
And at the time, did your daughter, was she named a conservator or have any rights to the child?
Jennifer and Calvin were just to visit possession only.
And to your knowledge, do you know if Calvin is incarcerated right now?
Based on what I heard from you, yes.
Now, since March 2023, so about 1.5 years ago, how many times have you moved homes?
I would not, rather not say.
I'm not asking you to give a current address. I'm just asking how many times you've moved in the last 1.5 years.
I haven't moved.
So you remained in the same home since March 2023?
Yes.
And have you changed your phone number since March 2023?
I had my phone number for over more than 15 years.
And do you recall that I tried to call you?
No,
You don't recall hanging up on me when I introduced myself?
I don't know who you are. I met you today. I know who you are today. I don't know who you are until today.
And you said your concerns about Miss Davis having some time with her granddaughter, your concerns are because of what Miss Davis's mother said about her.
Are based on Calvin and her mother, which are really close to her, I would assume. So yes,
And are you in agreement with Miss Davis at least having some sort of FaceTime or phone calls with her granddaughter?
I would say I don't agree to anything that's forceful through the court. I think we can, I mean, if she wants to show me a different version than what I have, we can set up a time and speak, but it wouldn't be forceful through the court. So no, not through the courts. One step at a time.
Are you willing to provide a current phone number to me, your current phone number?
I've had my phone number for 15 years. Same phone number.
No further questions for this witness, Your Honor, I pass.
All right, Ms. Rodriguez, now you're under oath. Is there anything under oath you'd like to tell me that I should know before I make a decision?
Under oath, I asked the courts to please allow me to continue to take care of my grandchild like I have. She's smart, growing up every day. And I would like to not be, how do I say this? I'd like to spend my time with her instead of spending my time with courts and spending my time with other things that I could be spending my time with, just more important than this. Also, I'd like to also state that there is no standing in this, and what I'm doing here, there's no standing. Mrs. Davis has no standing
Well,
based on her not seeing the baby for so long. The baby does not know who she is. And like I said, I do think that maybe we can talk and see if it's different than what I've heard from her mother and her son, but I don't have anything to go off of right now based on what I have. That's it.
okay. Ms. Warden?
I'm going to call Miss Davis to the stand,
Ms. Davis, if you would please raise your.
and she'll be 3 in October 14th of this year.
Yes, ma'am.
And you're the mother of Mr. Calvin Rickenbacker, correct?
Yeah.
And is your son currently incarcerated?
As far as I know, the last I heard last week.
So as of last week, he was incarcerated, correct?
Yeah, in my knowledge, yes.
So not at the time the lawsuit was filed.
I was just
Oh,
about,
yeah. I mean, yeah, he's been
I was-
in and out of jail.
that was my next line of questioning. So when you filed last year in August, was your son incarcerated, excuse me, at that time?
Yes, ma'am.
And when you filed in August of last year, was your son incarcerated for 3 months or more prior to filing?
Yes, ma'am.
And the orders are from March of 2023, and you filed in August of 2023. So during March to August of 2023, how many times did you get to see your granddaughter?
If I think I got to see her twice when Calvin had a visitation at my mother's house. And then after that, I haven't seen her since then.
And these, Calvin was supposed to get supervised visits, correct?
Yes, after he got out of one of the longest stint, the 3-month stint, he was allowed to go visit her under supervision. And I think he did that twice. But he's been in and out of jail, so he hasn't done it since.
And these were supervised
That
by
I
your
know of.
mother? I'm sorry, these were supervised by your mother?
Oh, before
Yes.
he went to jail, they were supervised by my mother. After he went to jail for the long stint, they were supervised by a third party.
Thank you. And did these supervised visits, did they last, how long did they last?
The ones with my mother, I think they were 5 hours.
And were you there the whole 5 hours?
Sorry,
The
it was it was an hour. It was about 2 hours, I believe.
Okay, hold on. You don't get to, I'll let you have a chance, but you don't get to interrupt. Thank you.
Okay.
So Miss Davis, how long was the visit supervised at your mother's?
I think they were 5 hours,
And how far do you live from your mom?
like 20 minutes.
Now, do you currently know where Miss Rodriguez lives?
Yes. Oh wait, which Rodriguez? My mother's last name is Rodriguez also. So
I'm sorry, the respondent in this case, Rosario Rodriguez.
no, I do not know where she lives. No.
Do you have a current phone number for her?
The one that I gave you was the last known phone number I had for her.
And when is the last time you tried to contact Miss Rosario Rodriguez directly?
I mean, probably over a year ago, and she told me not to bother her. I think I sent her a text message, and of course, I did not follow up with anything.
Did she ever block you to your knowledge?
I know that she did on Facebook years ago, but other than that, I don't know.
Do you know how long your son is going to remain incarcerated?
I do not.
Now, when you last saw Clementine, you said you were there the whole 4 or 5 hours?
Yes, ma'am.
And did you have any concerns about her behavior? Did y'all have a good time?
No, we had a good time.
Does she appear to be comfortable with you and your mother?
Yes.
And are you asking today that you get some grandparent access, just you, not your son?
Yes, ma'am.
And are you asking that this happen once a month on Saturdays?
Yes, please.
And you're not asking for any overnight time, correct?
No, I just want to be able to see her sometime.
And if you saw her, would you let your mother see her as well?
But yeah, I think so. We would probably meet at my mother's because that's the spot.
I'm sorry, when you say that's the spot, what do you mean?
Oh, that's just where we all gather all the time, and it's in Austin. It's just a convenient place, and we go over there and have dinner. She has a great backyard, so
So you guys get together at your mom's.
yeah, yeah.
And do you have any kids under 18?
I do. I have two other boys.
And how old is Calvin? Miss Davis, how old is Calvin?
Calvin is now 21.
And how old are your other kiddos?
My middle son is 17, and our youngest is fixing to turn 13.
And so you don't have any other grandkids, do you?
No, ma'am.
Clementine's your only one?
Yeah.
And are you asking today that aside from visitation that you be able to either FaceTime or talk to Clementine virtually or on the phone?
Yeah, that would be really awesome.
And do you think it's in Clementine's best interest that you have visitation with her?
Yes. Rose had stated that we saw Clementine before. Clementine lived with us for a while because Jennifer left her mom's house and came to our house. And I had taken over Jennifer's court order for when she first got arrested. And so Clementine lived with us for a good amount of time. And between me and my mom, we took care of Clementine while Jennifer worked
But
help.
Jennifer, hold on. You took care of her, but her mother was still around. You just cared for her, right? You didn't have custody of her.
I'm sorry. No, because Jennifer was living.
Okay, she was living. When?
I'm sorry, go ahead.
When was she living with you?
I'm sorry. That was before Jennifer went to prison. So I guess it's been about 2 years. Like when Clementine, after she was born, a couple of months after, a whole bunch of stuff happened, and Jennifer ended up moving in with us, with Calvin, and they lived with us for a while.
So that answered part of my question. So for how long the first time around did Jennifer, Calvin, and Clementine live with you?
Maybe 4 months, 6 months ish. I'm sorry, I can't give you exact dates. I really don't remember. It was pretty stressful. Calvin did make it stressful. Everything Rose says about Calvin is true. But on and off around 6 months, she lived with us.
And that 6 months, she must have been a little baby, correct?
Yeah, I mean, she was up until she was toddling, we were there for her first steps kind of thing.
And so aside from that 4 to 6 months, after that, you then saw her for the 2 supervised visits, correct?
Yes, after Jennifer went to prison.
And you haven't seen her in at least over a year since you filed. Is that right?
Right.
No
Yes,
further
ma'am.
questions. I'm sorry. No further questions for this witness, Your Honor. I pass.
All right. Ms. Warden, under what section do you allege? And by the way, I do find that Ms. Rodriguez filed a special exception, so she has filed something, so this wasn't a default. I mean, well,
Correct.
never noticed she's here. Under what section of the code are you alleging that your client has standing?
I'd have to bring up the actual number code, but for grandparent access, when the parent of the child, because Calvin is incarcerated, he was incarcerated the 3 months before the filing.
And he got out, and now she thinks he's incarcerated again, but she's not sure, if I understood the testimony.
As of last week, he was incarcerated again.
But we don't know for how long.
We don't know for how long. And he's been in and out since past the filing last year.
Okay. Well, let me say, you set this for a final order. You gave notice of setting it for a final order. Well, maybe it was, hold on. Was it within 45 days? Notice of final hearing. You set this on, you gave notice on June 27th. It's July 31st. That's less than 45 days.
Hmm.
So you can't have a final hearing. Right.
But, right, this was, well, once she didn't answer during the answer period, and then I had set the final hearing.
Well,
Sorry to-
you can only, hold on, Miss. It can't be a final hearing because it's contested and you didn't give 45 days notice. I'm concerned, well, here's what I'm going to do. I'm not sure that you can meet the standing requirements because nobody is sure how long Calvin is incarcerated. I'm concerned if Miss Davis, maybe through no fault of her own, I'm not making a comment about that, hasn't seen this child for 2.5 years. I'm not going to start saying she gets unsupervised, just the child goes on a Saturday because the child doesn't know her. The child has seen her. The last time she saw her was more than a year ago. Child can't remember her. So I think what I'm going to do I'm going to do a DRO appointment, a limited scope investigation for the DRO. Now I'm going to need some information.
Your Honor, can I ask you a question?
Excuse me,
Rodriguez. Is there probably it should be better for me to get an attorney. I thought, you know what I mean, to help me out. I did contact some attorneys and they did explain to me that it should be pretty easy, but I don't know the law as they do.
No, I agree. I'm going to make a finding that I don't think standing as required by the code has been established because the evidence is, we don't know where he is. We don't know how long he's in jail. So I can't find standing based on the evidence that was here today. So if you want to do that, and I'll find, this is a temporary order. I'm going to find that there wasn't appropriate notice given for a final order. If you want to do that, and I guess I'll hold off, Ms. Warden. You can make a request for DRO, but I don't have sufficient evidence to find that Ms. Davis has standing under the code.
Okay, and you're not gonna request the limited scope for the DRO, but I can.
You can give Ms. Rodriguez a chance if she wants to hire an attorney, but unless Ms. Rodriguez, if you want to do that, or I could appoint the guardian ad litem of the domestic relations office to do an investigation, which is going to be, where is Calvin? How long is he going to be gone? If he's in jail for, 3 months, a month, she may not have standing.
Okay. Yes, we can try that. And then I'll contact the people that I know and go from there.
Okay. I'm going to need some information from all of you to fill out a DRO limited scope.
Courtroom. I thought it was going to be in person. So the lady here helped me get on Zoom and everything. I can give her my information if you'd like.
Oh, you're here in the courthouse?
Yeah.
Oh, yeah, that's the other issue. That's another problem with it does say this hearing will take place remotely. There had to be an agreement, but we moved forward. So, Ms. Warden.
Well, again, Your Honor, she had defaulted she had not responded to
She filed a special exception.
No, I understand that, but I had already set the hearing. She had not responded after being served within the required amount of time, so I set the hearing after that. And at the time, when there's no one on the other side to announce, that's why I did it Zoom.
Well, it doesn't matter that there's no attorney. Once you know she's there, the rules require, unless you have an agreement from both sides, that a hearing will be remote. It must be in person.
I understand. I didn't say anything about an attorney. If someone defaults, then there's.
Never mind. You and I are talking over each other. She didn't default. She has a pleading on file, so she didn't default.
I'm sorry, Your Honor. I meant if someone doesn't answer on their time period, when I set the hearing, that I understand what you're saying.
But you set the hearing after she filed a pleading, so what you're saying doesn't make any sense. It doesn't matter. Ms. Rodriguez, I'm going to ask you to come up to the 11th floor, and I'm going to have a member of my staff bring you out the DRO form. I do see in the final order that her address is kept confidential. So I'm not gonna make her disclose that in a public record. I'm gonna, there'll be a phone number. I got to have a way for the DRO to get hold of her. But and then Ms. Warden, I'll send you the DRO form for you to fill out the information about Ms. Davis and yourself. And
okay, thank you.
I'll fill that out. But Ms. Rodriguez, if you would just come up to the 11th floor, the public area of the 11th floor, and wait around, one of us will be out. Somebody from my staff will be out to bring you the paperwork you need to fill out in about 5 or 10 minutes. Okay?
Yes, I'm in the 11th floor, 11D courtroom.
Oh, you are?
in your courtroom. And
Who,
the
who let you in there? Well, I'm sorry, I would have been in there.
sheriff let me borrow the charger, and then they helped me get on Zoom. So
I wish the sheriff had let me know. I'm sorry, I apologize. And all right.
thank you.
All right, yeah, but so in the future, unless, unless it's a real default, it has to be in person, Ms. Warden, unless we get agreement from everybody that it can be.
Yes, Your Honor. And I did want to quote, it was 153.433, possession of access to a grandchild. And if the parent has been incarcerated in jail for a 3-month period preceding the petition, the filing of the petition. And that's what she testified to, as far as the time she filed and how long he had been incarcerated.
And does not have actual or court-ordered possession of the child. I don't think she has standing because 153.4333 requires that the father not have actual or court-ordered possession of the child, and he does,
Okay.
right?
Okay.
All right, so
Also willing, if Ms. Davis would like to contact me personally, she has my phone number. I'm willing to speak to her and take it little by little without the courts.
I think that would, I would hope that you all would do that, because I do think there's a standing issue. I do, even if there wasn't, I would not give Ms. Davis the relief she requested today, because this is a baby and she doesn't remember Ms. Davis. Maybe she deserves a chance to get to know her, but to say she hasn't seen her for over a year since she was 2, she's not going to remember her from 4 or 5 hours seeing her once or twice. I hope that y'all will talk to each other and maybe could work something out. All right.
That would be great. Thank you, Your Honor.
Thank you. You all may be excused. Matter of the marriage of Sloan. Once again, appearances for the record, please.
Rob McAngus for petitioner Michelle Sloan.
And Gregory Sloan, pro se.
Thank you. All right, Mr. McAngus.
Yes, Judge. 2 motions are set. One's a motion to enter. We want to address that. And then there's a motion to divide undivided property that I can explain after we go through the motion to enter. And then if possible, I'd like to call my client to do prove up questions while we're here and knock that out.
Sure, of course.
Prove up the divorce.
Let's take up the motion for undivided property, because I read that while we were on break. And
okay, sure thing.
I understand it. Y'all signed an MSA that, well, it says it failed to divide the parties' marital interest in the Dodge Ram, right?
Correct, Judge. What happened was we were under the impression that, and this happened prior to my appearance in this case, with previous counsel. There was discussions with, at the time, Mr. Sloan's attorney, from what I understand, and Ms. Sloan's prior counsel about this Dodge truck. It was our understanding that Mr. Sloan had sold it, and so which was not agreed upon. And so in the MSA at mediation, he asked for the title, which raised the red flag of why needing that. But we thought, well, okay, because it was solely in my client's name. We weren't sure how he disposed of it. Then we found out that it was sitting at the dealership, and that it was not disclosed to us that it had not been, it's been returned to Mr. Sloan. We found that out after the fact. We would have never agreed for him to be awarded the vehicle because that was not part of what was discussed.
Well, but here's what I'm confused about. I'm looking at the MSA. I'm looking at it's page 13 of your motion to enter. Schedule B, property and liabilities, the husband. Maybe it's not the same car. Number 5. The following motor vehicle. 2023 Dodge Ram.
Correct. It's actually right below it, number 6. Wife shall deliver the title for the 2013 Dodge Ram. It's actually neither of those vehicles. It's a 2012 Dodge Ram, but I think the 2013 Dodge Ram was a typo in the MSA. But
was there ever more? Oh, let me ask this question. Was there only ever one Dodge Ram, whether it was 12, 13, or 15?
No, there were 2.
All right. There are 2.
Ma'am.
Okay, hold on.
No, ma'am, there was a 2012 Dodge Ram.
I'm not Mr. Sloan. I'll get to you. Hold on.
Thank you. Sorry.
There was a 2012 that's listed on number 6 of the MSA with it as a 13, but we all agree that should have been the 12.
Correct.
All right. Well, okay, make your argument, but if it says she'll deliver the title, it seems like y'all thought it was sold, and I would assume that you didn't, everybody would have said he got money for it, and that was part of the.
Well, Mr. Sloan purchased the 2023 Dodge Ram as a trade-in, is what we understood. And so the money was therefore put into the 2023. And so had we known that the 2012 had not been disposed of, we would have addressed it. And that's why we filed a motion to divide undivided property from the standpoint of, we didn't realize that he wasn't being truthful at the time of mediation. And so had we known that, we wouldn't have agreed to that portion of it.
I get it, but in any event, whether it had been sold, the 2012 had been sold and put into a 2023, the value of whatever the 2012 was is accounted for in your MSA. Because you assumed that he traded it in on the 2023, right?
That's what we found out after the fact when we asked Mr. Sloan for why the reason for the title. And that's when we talked to the dealership and realized that that's how he had disposed of it, was to try and trade it in, but they would not take it without the title. We didn't realize that at the time.
Okay, so the 2023 Dodge Ram doesn't exist, yes or no? It's not owned by anybody, or it is?
Yes.
It does. Mr. Sloan was awarded that. I don't know, unless he's disposed of it since mediation. I don't know, but he had it at the time of the MSA. I don't know. I'm assuming he still has it.
Okay, but I still get to, there's value, whether it's a car or the value of the car that went into another vehicle.
Right. And to clarify, we didn't know that he had tried to use it as a trade-in at the time of the MSA. When we heard from the dealership.
Does it matter if you say in here he's going to deliver the title? I mean, I'm just looking at one place. Does the MSA say anywhere else what happens? I mean, somebody must have known that it wasn't around, or they would have said it's awarded to one or the other. People clearly knew about the 2012/13 Dodge Ram.
Correct. All we understood from Mr. Sloan's representation was that he'd gotten rid of it.
In some ways, Mr. McAngus, you weren't there, I wasn't there, and it doesn't matter.
Correct.
What anybody understood, doesn't it? Just all that matters is what's written here, right?
I agree with that. Yes, it does matter based on what is in the MSA. Our position was just, we didn't realize that it had not been disposed of. That's all. And so that's why we're asking the court to divide that value, essentially, because it had not been disposed of.
Okay, I get it, but well, I guess I need to hear some evidence. But from what I understand so far, people assumed it was disposed of, which is why it says turn over the title. Whatever intrinsic value that truck had was accounted for somehow, it seems to me, because it says he gets the 2023. We assumed that he rolled over the old one to the purchase of the new one, right?
No, my client did not know that. I hear what you're saying, Judge. I can call her to testify and put on testimony about her understanding of it. I agree. I was not there.
Okay, well, let me hear from Mr. Sloan by way of opening, and then I'll hear evidence. Okay, Mr. Sloan.
Good morning, Your Honor. I'd like to point Mrs. Sloan's counsel to Exhibit N in the materials. And the day before,
materials, let's be specific. So, or
the pre-marked materials that I put into this case here today, ma'am.
In box, then can you
in box?
I need you to. Why don't you pull them up so that we can all see them? Do you know how to do that?
I do not. So let me figure this out real quick.
Mr. McAngus, do you know how to do that for him?
Yes, Judge. Was it, which one are you referring to, Mr. Sloan? Sorry.
Exhibit N. Just open it.
Yeah, I can share my screen.
Okay, share that. If you look at the date, sir, it was addressed.
Hold on. Let's all look at this.
Okay.
First of all, this isn't evidence. We're just making arguments. So it may be.
Well, I'm just going to go to the point, Your Honor, that I did disclose on September the 5th, the day before the mediated settlement agreement, the exact details of the trade-in, why I was trading it in, and the valuation of it. And I gave the combined equity of $27,000 total with the trade-in of that and the 2013 Porsche I traded in at the same time. Both needed significant repairs, yet I owed $14,328 for the Porsche. And then so I go, thus you can put $12,672 in the equity.
I don't see what you're reading from.
Well, he pulled up the wrong exhibit. Pull up Exhibit N, sir.
This is Exhibit N.
Okay, hang on.
If you have it pulled up, Mr. Sloan, then go to share screen at the bottom of your.
There you go. There you go. I can do that.
Okay.
I can do that. Thank you.
Yeah.
Yes, sir. This was a note that I sent to you and counsel on Tuesday, September 5th, the day before the mediated settlement agreement. disclosing the vehicles, disclosing the value.
Right. But, oh, sorry. I understand this argument. Go ahead, Judge, or Mr. Sloan.
Okay. So I'm just going to the point that it was disclosed, it was discussed. This was the only asset of material value I received from the entire division of property, where your client received close to $400,000 in assets, kept all the appliances, all the furniture, all several of my possessions, kept the 2020 tax return directed to her to direct deposit.
Okay, all right. This is just an opening, and then I'll hear evidence. Okay.
Amen.
So
But I'm just going to the fact this was disclosed, and then it was clearly the intent that this was to be my property and the only property I left the marriage with.
Okay. All right. Let's take that down. Mr. McAngus, if you want to put on any evidence about this issue, but then we'll get that in. So.
Okay. I'll call Michelle Sloan. And
Ms.
you
Sloan,
are
please raise your
currently
hand.
married to Greg Sloan. Is that correct?
Yes,
And you guys were married on or about April 28th, 2013, but have ceased living together as husband and wife?
April 28th, 2013.
Okay. And prior to the filing of this lawsuit, were you a resident of Travis County for the preceding 6 months?
Yes, I was.
And has your marriage become insupportable because of a discord or conflict of personalities that destroys the legitimate ends of the marriage relationship?
Yes.
Is there any hope of reconciliation?
No.
All right. And during the marriage, did you and Mr. Sloan have any children together?
We have one son, Jackson.
And state his full name and age for the court, please.
He is 10 years old.
Were there any other children born or adopted during the marriage?
No.
Are you expecting at this time?
No.
All right. And you and your husband entered into an agreement at mediation and signed a mediated settlement agreement that resolved all the issues as it relates to conservatorship, possession access, child support, and health insurance for Jackson, correct?
Correct.
And you believe that those agreements were in the best interest of your son?
Certainly.
And you also entered an agreement with Mr. Sloan as it relates to the division of property and liabilities with you guys. Is that correct?
Correct.
And aside from the issue of the truck, which we'll talk about here in a second, you believe that's a just and right division of the community estate?
Correct.
And then you understand that we're going to also talk about the decree form, but we plan to enter a decree that mirrors the terms of the mediated settlement agreement. Is that correct?
Correct.
All right. I'll pass the witness. Oh, no, I won't pass the witness. Sorry. So used to doing that in the proof up. I lied. I will not pass the witness.
Okay.
Now I'm going to ask you about the truck. Sorry. The reason why I was doing that, Michelle, just so you know, Mr. Sloan, those proof up questions are required anytime you're going to finalize the divorce. So that needed to be done. So I was taking care of that. Ms. Sloan, what was your understanding of where the 2012 Dodge was at the time of mediation?
So I did not understand that, or on August 30th, I went into the DMV to prepare to get a copy of the title to prepare for the upcoming settlement hearing that we were going to have. And when I got that, I got a copy of it because my name is the only person on the title. And then I guess that triggered something with Greg in the dealership. And then he started getting calls from them. And then he started asking me about it, or you, or I don't know, whoever he asked about it. And I didn't understand how he was able to sell the asset without my permission because I never granted it. At the time of the ex parte order, I had possession of the truck.
I'm
and
sorry,
my,
hold on. I'm going to interrupt you. What ex parte order?
that's the whole thing that started the divorce.
Okay, so at the beginning, but you had temporary orders after that. Okay, I just didn't know what you were talking about and how that's relevant to this issue.
So,
Well, so I had the truck in that.
right. I'll kind of try to fast track this, Michelle, but you understand then you guys entered into temporary orders prior to when I was an attorney, your attorney of record, where I believe in the temporary orders, Mr. Sloan was allowed to drive the 2012 while the case was pending. Is that correct?
Right.
All right. So did you understand we're trying to explain to the court because the judge is asking, it's a fair question. Basically the judge was asking if you knew that had been traded in at the time, then what what the judge was basically saying, well, then the value of the trade-in was included in that 2023. So that's why we need to explain to her, if that was already included in the value of the 2023, why are we asking to divide it? What is your understanding?
My understanding is that my other attorneys told me he could not sell that vehicle without.
I'm going to caution you about waiving your attorney-client privilege. That is, if you start repeating what your attorneys told you, we can get into that, and you don't want to do that.
Okay.
Yeah. I'm just asking.
It's my understanding that nothing could happen to the vehicle until we both came to agreement on it.
All right. So as we sit today, what vehicles, in your understanding, does Mr. Sloan have in his possession?
He has the 2012 Ram and the new one that he bought.
The 2023.
2023.
So if that's the case, then the 2012 Ram trade-in is not included in that value of the 2023 Ram in his possession, correct?
Right.
Okay, and that's why you're asking for the court, because regardless of what the situation is at mediation, today as we sit, he has a 2023 Ram and the 2012. So it's not wrapped up in the value of the 2023 as we sit today, correct?
Right.
You understand, because the judge was saying, hey, if you traded it in to the, and to get the 2023, then let's say it was worth, $10,000 and he put $10,000 towards the 2023, then by awarding him the 2023 Ram, he essentially has that $10,000 value already in his column. Does that make sense? Do you understand that part of it?
Mm-hmm.
Yes. So you got to say yes. Court order.
Yes.
And so as we sit here today, though, he has both vehicles in his possession, correct?
Correct.
And that's why we're asking to divide the value of the 2012, because it's not, he still has the 2023. It's not included in the value of that as we sit here today, correct?
Correct.
Okay. I'll pass the witness.
Mr. Sloan, do you have any questions for Ms. Sloan?
Ms. Sloan, do you know who the owner is of the 2023 Dodge Ram?
Me. My name is on the title.
On the 2023 Dodge Ram?
23. You and your girlfriend, I think.
So Shannon Livingston is the primary owner of it. I was a co-signer of it. Okay, so she's the primary on it. It's truly her asset. Okay, let's start there. And when we purchased the 2012 Dodge Ram, why was the reason you're the only name on the note and on the title of the vehicle?
Because you told me that I had to, and I was the only person with good credit.
Thank you. Was I going through a bankruptcy and I could not apply for credit at that time?
Yeah. Yes.
Ms. Sloan, did you make a single payment during the time of our marriage on that 2012 Dodge Ram?
That's irrelevant.
Yes.
That's irrelevant, because even whoever made a payment is presumptively community property.
Fair enough. Ms. Sloan, other than the 2012 Dodge Ram and the 2013 Porsche Panamera, what assets of the household did I leave the marital establishment with?
Judge, I'm going to object to relevance.
I agree. It's not relevant. It's not relevant. Y'all made a deal.
Okay. I have no further questions.
Right. I have a question. Ms. Sloan, well, here's what I don't understand. Why does your MSA say you're going to deliver the title to him? Because you thought he had sold it? Yes or no?
I thought he wanted it for his records. I didn't, because I never agreed to sign anything. It was my understanding that he could not have gone through with the sale or done anything with that.
Okay, hold on. My question's real simple. The MSA says you're going to deliver the title to the 2013, we all agree is 2012, Dodge Ram. It doesn't say he gets the car. It says he gets the 2023. Why would you say you're going to deliver a title? Why would you just give him the title instead of having that awarded to him? This is what didn't make sense to me.
This was an 8-hour long ordeal that we went through, and this is like the last thing that we were arguing about. And
okay, but I just listen to my question. Why would you sign a document that says you're going to give him the title to the 2012 or 13 Dodge Ram?
For his memory box. It wasn't.
Where did you think the Dodge Ram was? When you signed the document, did you think it had been sold?
Yes, I did.
And that's the reason it's not awarded, because, and why you were only going to give him the title, correct?
I'm confused. I didn't think that he was able to do it, to sell it. So he decided to go in and sell this thing. But how did he do that? Because without legal authority, he couldn't do it. So
And that's why
it
you
was
were giving,
an
right.
undivided asset. To me, it was an undivided asset because,
Michelle, but
yes,
don't interrupt the judge.
That's all right. I got it. I understand. I don't, Mr. McAngus, do you need to, you want to follow up with anything?
Just to clarify, or I guess the reason why you're asking to deal with that asset as we sit here today is because it wasn't indeed what was represented to you. It was not sold. He still has it in his possession, correct?
correct.
Okay. And he also has the 2023, which he represented in his email that he aptly provided, Exhibit G, that he had traded it in. And you found out that wasn't the case because he has both vehicles as we sit here today, correct?
Correct.
All right.
But did you admit, let me ask you, Ms. Sloan, you saw exhibit G that we saw earlier, and I guess we should admit into evidence. Everybody was aware before the mediation.
Did you want
He
me
told you all that, probably still aware of the vehicle's location. Please have your client turn over the title. It'd be nice to provide them with the spare keys.
right.
Yeah, so clearly he was trying to sell it, right? That's
He
what
had done,
everybody knew at the time of the mediation.
well, we asked him how he was able to do it. And what
Okay.
the mediator said was,
That wasn't my question. At the mediation, you knew that the document we just saw, everybody was aware he was trying to sell it. And that's why he needed the title. Yes or no?
I didn't think he could do it.
Then why did
Because
you
he didn't.
sign this thing saying he could have the title to it?
Just to clarify, she thought it had already been done based on his representation.
I agree. And it sounds
Okay.
like the only reason, and did you ever give him the title as set out in the MSA?
Yes.
I gave him the title, yes.
Objection, Your Honor. She gave me an unsigned title. It was the dealership was unable to do anything with it. That's why they had to return it to me, because they could not resell that vehicle because the title was not transferable.
Well, if there's Miss Sloan, do you agree
Yes,
with
ma'am.
that? Did you give him a signed title?
I did not give him a signed title.
Okay. Even though you were supposed to under the MSA.
It never said that I had to sign it. Like, he went into the dealership and did this on his own because before even we had the MSA. So he deprived me of this.
But I understand, but the point is everybody knew this at the time they signed the MSA. I've seen evidence now that everybody knew that it was at the Nile Maxwell. He was trying to sell it. And that's why it says you're to give him the title.
Okay.
I mean, otherwise I can't understand why you would sign a document that says you're going to deliver him a title.
I didn't think that that was giving him the ownership of the vehicle.
What did you think giving him the title? What was the purpose of giving him the
For
title?
for his records. Something to remember me by. I don't know.
All right. Any, Mr. McAngus, do you want to put on any other evidence about this issue?
No, Judge.
Mr. Sloan, do you want to offer Exhibit G?
Yes, I would like to offer that as evidence.
Mr. McAngus, do you have any objection to Exhibit G?
No objection.
Exhibit G is admitted. All right. All I can do is interpret the MSA. I can think of no reason that somebody would be required to turn over a title to another person unless that the Dodge Ram was going to be sold or given or awarded to him. So Ms. Sloan's motion to divide undivided property is granted, but the Dodge Ram is awarded to Mr. Sloan.
Understood. Thank you, Judge.
Thank you. All right. Do we have any other issues about the form of the decree that we need to go over?
Yes, Judge.
Okay. Great.
And if I may share my screen.
Yes,
I
please.
uploaded just kind of a summary of the Can you see this, Mr.
Yes.
Sloan, Judge? So these are the disputes. Mr. Sloan sent us a summary of the issues he has with the proposed language in the decree that's drafted. So issue number one, as far as travel expenses, the MSA states that if wife elects to move outside of Texas, she'll pay all airfare travel expenses for the child. If the parties live more than 100 miles apart, the visitation shall follow the possession schedule for more than 100 miles. If wife moves further than 100 miles from husband, the exchanges of the child shall occur approximately halfway between the parties' residences and public area. If husband moves outside of Texas, the geographic restriction is lifted and the wife's obligation to pay all airfare travel expenses for the child is terminated. Our language in the proposed decree says, in the event that Michelle elects to change the primary residence of the child outside of the state of Texas and Gregory Cameron Sloan resides in the state of Texas, it's ordered that Michelle Antoinette Sloan shall be responsible for the payment of all airfare travel expenses for the child for the purposes of visits with Gregory
Slow
Cameron.
down. I have a court reporter trying to take what you're reading.
I'm sorry, I didn't even think about that. I apologize. It is ordered that Michelle shall be responsible for payment of all airfare travel expenses for the child for the purposes of visits with Mr. Sloan that require airfare travel in accordance with the applicable possession schedule, which mirrors the language in the MSA, that if she moves outside of Texas, she pays the airfare. In the event that Gregory Cameron Sloan does not reside in Texas, Michelle Antoinette Sloan's obligation to pay airfare travel expenses for the child is terminated, which mirrors the language in the MSA. Mr. Sloan asked that we put language in the decree that states husband requests wife pay for airfare every first, third, and fifth weekend each and every month Jackson is in school.
Okay, Mr. Sloan, let me ask you, what is there anything, do you disagree with this chart that the first column, it mirrors the MSA language?
No, I don't disagree, and I keep on asking me questions, Your Honor, because
Well, if that's the case, I don't have any authority to order her to pay airfare every first, third, and fifth weekend, unless.
I wanted to clarify. I misinterpreted because if she did move out of the state, the 100-mile rule does apply. Hopefully what you get the gist is I want to stay within 100 miles of our son Jackson.
Well, that's not the deal you made. That's not, I can't change.
I know. Okay, but then if it goes to that, then I absolutely understand that I get them per the rules, 100 miles. She needs to be paying for airfare. I just want clarity around that.
Not if you're all in the state of Texas. That's not what this says.
If it's in the state of Texas, please clarify, Your Honor.
I can only, the purpose, we're now at a point where I'm not taking evidence. I'm ruling what the MSA says. So I'm looking at the MSA on page 4.
And I can switch to that if
Thank you, sir.
sure thing. Page 4 of the MSA.
Well, that's what your chart said. So.
Yeah, I sure hope that's what it's. I gave you the right page number. Let me see.
I don't know that you did.
I might not have, Judge. And I truly.
That's all right. We'll find it.
Oh, yeah. Oh,
There.
look.
Okay.
Page 4 of because the MSA cover sheet.
All right. So, Mr. Sloan, you agreed that she can establish the residence of the child in Texas, Florida, DC, and Arizona. So I can't require her to stay within 100 miles of you. So,
I agree with that. I have no objection to the language on the
great.
on the MSA. Let's move.
All right. The second one, Judge, the exchange language. For all exchanges that do not occur at school, the exchange shall occur at Fire Station 38, located on Anderson Mill Road, unless another location is agreed in writing by the parties. That's on page 5 of the MSA. Page 4 of the, and then the geographic restriction. If wife moves further than 100 miles from husband, the exchanges of the child shall occur approximately halfway between the parties' residences in a public area. Our language states when the parties live less than 100 miles apart, that the exchanges, if they're not at school, shall occur at Fire Station 38. In the event that Michelle moves more than 100 miles from Gregory Sloan's residence, the exchange of the child shall occur approximately halfway between the residences and public area. In the event that Gregory Sloan resides more than 100 miles or more from the child's residence, the exchange of the child shall occur at the child's school or Fire Station 38. Husband proposes the exchanges occur at Michelle Sloan's residence instead of the firehouse. That's not in the MSA. This is husband's request.
Right, I see it. So, let's start one at a time. Mr. Sloan, unless she agrees that the language, all I can do is have the language reflect the MSA. So
that's fine, Your Honor. I just feel like it's causing our child unnecessary stress when he literally lives less than 200 yards from that fire station, and it'd be a lot easier just to drop them off.
Well, I can't change what y'all agreed to.
Okay, so I just would ask his client to reconsider the stress that she's putting her child in. I'll abide by what's in the MSA. Let's move on.
The next one, payment of child support. Gregory Sloan shall pay $1,840 per month to begin on October 1st, 2023.
You don't need to read it all, Mr.
Oh, I apologize. So
It seems like we're in alignment here too. Basically, it says the same thing, split equally among paychecks. I just want to be clear on it.
Okay, so you withdraw that objection.
Mhm.
information.
If she wants it withheld, is there anything in the MSA that says she can withhold her information?
No, Judge, we're just basing it on the statute at that point. It's silent as to information regarding the parties. And just based on the history of this case. And
Objection. Everything's dismissed and expunged.
Yeah, I mean,
Doesn't mean it didn't happen.
Ms. Sloan, it's not your turn. I understand, but the code requires that information be included absent certain circumstances. If they didn't agree to it, I'm not going to withhold it. And apparently he knows where she lives anyway. I can't withhold it if it's not in the MSA. What's good for the goose is good for the gander. I mean,
Isn't it? I thought it was in the MSA.
that your information be withheld.
No, that it was listed like that, or that was just the way that the orders were.
That's just the order.
Oh, I see.
Okay.
I thought that's what the orders were. I thought that was the same thing.
All right. So understood, Judge. We'll put the information in based on your ruling.
well, and here's the other thing I'm looking, I bet it's included in the temporary orders anyway, isn't it?
Yeah.
So, okay, go ahead.
No, it's not. It's withheld in the temporary
It's
orders.
withheld. It's finding a good cause underneath that. The court
Well,
creeps it down. Yeah.
That should have been part of the MSA. I mean, I realized, but
Understood. Payments between the parties.
I'll withdraw this objection. I reread the MSA, the way it's worded in the proposed orders. I got slightly confused. Okay, so we're good.
thank you.
Attorney's fees and costs. MSA, it states that Mr. Sloan will be responsible for any attorneys and court fees associated with enforcing the judgment or enforcing money owed. He stated that he wants it to apply to both of them, but the MSA only applied to him.
If it only applies to him, then that's what it's going to be, Mr. Sloan. If you have to enforce it, I mean, typically anybody who brings an enforcement that's found to be valid usually gets attorney's fees. But if it didn't, I'm not going to put that in there if it wasn't part of the MSA.
Fair enough, Your Honor.
The next issue, Mr. Sloan requested that the decree state language regarding the child's phone. The MSA is silent, so we left it out.
I can't add any terms that aren't in the MSA, Mr. Sloan.
Understood. I just wish the client, your client would consider access to the father, but fair enough. I understand.
And then the last issue was the
Dodge Ram. Yeah, and I'm sorry. To me, the issue with the car seems pretty clear. I mean,
understood.
Okay. All
What I can do, Judge, is I can reform the order to include the information regarding the parties for Ms. Sloan. I'll add in language about the 2012 Dodge based on your ruling about granting the motion but awarding it to Mr. Sloan. I'll make that clear, and then I'll circulate it to Mr. Sloan for signature, and then hopefully we can submit it to the court.
I also want to be clear that I'm not paying your attorney's fees for bringing that claim of the Dodge Ram.
Mr. Sloan, he didn't ask for it. You don't need to worry about it. Just, okay.
Thank you.
I need
it did in the proposed orders, Your Honor, so I wanted to make sure you understood that. In the proposed orders you granted, okay, and I wanted to make sure that was not included. Thank you.
Now, Mr. McAngus, do I need to sign a wage withholding order as well? Any other?
Yes, Judge. I'll submit a income withholding order as well.
All right, as well as a BVS form, please.
Yes.
Okay. Could you please send those to my submission email address? No, I'm not sure you know what that is.
I definitely don't know what it is, Judge. My
I'll tell you.
paralegal might, but I will not lie and say that I do. So if you don't
No,
mind.
I didn't think so. We have a standing order. If you were here, we all have the same as my court number, which is 419.submission@Travis County altogether spelled out tx.gov.
Understood. I will do
And
that.
if you would, when you send the email, please make a note that it's from today's hearing.
Okay.
As soon as I get the that decree and the wage withholding order and the BVS, I will sign them and get them filed for you.
Thank you, Judge.
Thank you
Thank
all.
you, Your Honor.
May we be excused?
Yeah.